Now we turn our attention to a complicated, difficult criminal law and procedure hypothetical. It's a long, complicated fact pattern, and the calls of the question don't give us a great deal of help. So let's start by looking at the calls of the question. 1. How should the federal appeal court rule? Discuss. Well, that doesn't really tell us anything. We could be in a torts question, contracts, corporations, civil procedure, or criminal law and procedure. Look at call of the question number 2. Was the state trial court's denial of the motions to dismiss correct? Discuss. Well, here again, this might as well be civil procedure rather than criminal procedure. And call of the question 3, how should the state trial court rule on Mike's motion for a directed verdict? Discuss. Again, this is not very helpful at all. For these questions, we know that we'll have to consider what the standard of review is for whatever the issue is. We'll have to narrowly consider whatever the motions are, and then reach some sort of reasonable conclusion. But these calls of the question do nothing to help us organize our answer, and they do nothing to clue us in as to what the real issues are. So we then turn to the top of the question, and it doesn't take us very long to realize that we're dealing with criminal law and procedure. In paragraph 1, we meet Dan and we meet Paul. Dan is the principal bad guy in the fact pattern. He decides to rob a bank. He tries to get Paul to help him do it. Paul agrees in paragraph 1 to help him do it, secretly resolving to thwart the robbery. Well, at the moment of the agreement, we've probably got a conspiracy. And as it turns out, that's going to be one of the issues below. In paragraph 2, we meet Mike. And here we learn that Mike is a victim, pure and simple in this case. He's basically kidnapped at gunpoint and told he's going to help out with this robbery. In paragraph 3, we've got the trio arriving at the bank, and the various parties take their positions. It's clear here that Paul fails to act to thwart this robbery. So it looks as if there's been a conspiracy in paragraph 1, and by paragraph 3, it looks as if Paul is going to be as liable as Dan for anything that goes on. In paragraph 4, we meet Fred, our victim. Fred shows up, and he is shot basically on sight by Dan. So one of Mike's arguments about any criminal charges relating to the shooting of this victim is that he's not the trigger man, Dan is. And we know that accomplices are liable for crimes committed by co-accomplices and co-conspirators that are done in furtherance of the criminal plans. Next, we turn to the final 3 paragraphs of the question. Each one of them corresponds with a call of the question. So, the 3rd paragraph from the bottom corresponds with call of the question number 1. We've got the 2 principal defendants, Dan and Paul, appealing from their convictions that the evidence doesn't support either the federal assault statute conviction or conspiracy to violate that statute. So now we can organize the first call of the question fairly well. We'll break it down between the 2 charges and separately discuss the 2 defendants. In call of the question number 2, we find out about the motions to dismiss. And here we've got a double jeopardy claim. And it's a fairly simple and straightforward one, as it turns out, because we've got a separate sovereign and we've got a changed factual circumstance in that the victim has died of his wounds. Then finally, the last paragraph in the fact pattern corresponds with the 3rd call of the question. Here we've got Mike asking for a directed verdict of acquittal, and it seems evident that Mike is probably going to be entitled to the relief that he is seeking. And we reach the calls of the question again. So this is a complicated, difficult fact pattern, but in the general scheme of things, compared to, say, contracts or real property, this is not a hugely difficult question. The reading and organization principles that we can learn from this question are fairly straightforward. The call of the question just refers to various motions. But in the body of the fact pattern, we learn about what those motions are, and it allows us to set up our answer neatly and in a way that is intuitively sensible for the chain-smoking solo practitioner who's likely to be judging your work on the essays. So please turn the page with me for a moment, and let's take a look together at how I've chosen to organize an analysis to this fact pattern, and let's carefully consider what good analysis would be and what conclusions that analysis would add up to. Obviously, the first of the three calls of the question is by far the most complicated, and it's the one that we will spend the most time on analytically. Certainly, we could also imagine multi-state questions focusing our attention on the possible liability of these two defendants. So, I begin with Paul. One could easily do it in the opposite order, but I think that it's better to start with Paul. And I conclude that Paul's appeals from these convictions are going to fail. He's being charged with conspiracy and with violation of the federal assault statute. As we consider the analysis that Paul's appeal requires with regard to conspiracy, we have to define conspiracy. We know that it's an agreement between two or more people to commit a crime. We also know that some jurisdictions require a substantial step, and others do not. But here, there has been both an agreement and, in fact, the crime of bank robbery was completed by these defendants. So the mere fact that Paul initially thought that Dan was joking, and the other mere fact that Paul, in his heart, at the time of the agreement, resolved to try to thwart the crime, those combinations aren't good enough to defeat the fact that Paul, in fact, agreed to participate in this robbery and to use force. And that's enough to establish conspiracy, and that crime is completed at the moment of the agreement, really. Now we move on to the appeal that Paul will bring for violation of the federal assault statute. And we know from our reading of the facts that Paul didn't shoot this victim. He did not directly assault the victim. But Paul is both a co-conspirator and an accomplice, and this shooting was entirely foreseeable. If you're going to rob a bank and carry guns and some victim gets shot at the robbery, I think all of us can agree that everybody who is a true conspirator is going to be convicted of a crime relating to that act of violence. So, the bottom line with regard to Paul's appeal is it fails. He's guilty both of conspiracy and of violation of this federal assault statute. And the fact that he didn't intend to assault this guy, and the fact that he didn't even know that this victim had anything to do with the government, isn't enough for him to escape criminal liability. Now, let's turn to Dan's appeal. If Paul's appeal is going to fail, Dan's appeal is even on weaker ground. Why is that? Because Dan's the leader of this crime. He never flagged for a moment in his criminal intent, unlike Paul, who arguably felt as if he was sort of being cornered into this affair. We're told that Paul felt it would be dangerous for him to back out, but he never should have entered into this agreement already. So, was Dan guilty of conspiracy? Answer, yes. He's the guy that got Paul involved in this case in the first place. And at the moment that Paul agreed, Dan also is guilty of conspiracy. And with regard to violating the federal assault statute, the crime that Dan committed is even more plainly obvious than the crime committed by Paul. Why is that? It's because Dan is the shooter, and the shooter is certainly going to face criminal liability for that act of violence. Next, we turn to the second call of the question, and we're dealing with double jeopardy. And there are two details that we've got to focus on here. The obvious one, and the one that answers the question pretty much up front, is the fact that we've got separate sovereigns. The first case was a federal case. The new case is a state case. The state is a different sovereign than the federal government. Therefore, it is not a violation of double jeopardy to try these guys in state court. But there's one other detail that makes this even more strongly not an example of double jeopardy, and that is that the victim has died of his wounds since the federal case ended. So now the state court's got an interest in trying these two guys for murder, not merely assault. The bottom line is, with regard to the second call of the question, the separate sovereigns argument fails, and double jeopardy, actually the separate sovereigns argument is the winner for the prosecution. The appeal fails, and double jeopardy will not afford either of these defendants an avenue toward acquittal. So finally we turn to Mike. Now Mike is the only one of these three defendants who has real defenses to the charges. Mike is really just another victim. He's not a co-conspirator. He never agreed to use force. He was subject to physical duress the entire time. Now, suppose the facts were different. Suppose Mike had been the shooter. Well, at that point, Mike's defense obviously would collapse. But this guy didn't even have a real weapon. Well, he had a weapon, but it was unloaded. Mike was not in a position to do anything to hurt anybody. He was just basically taking up space because Dan and Paul dragooned him into this effort. So, is he guilty of violating the federal assault statute? Answer, no. He had no intent whatsoever, and he was not a party to the conspiracy, nor was he an accomplice to the other criminals. Thus, he escapes liability directly, and he escapes liability as an accomplice or a co-conspirator, because he's neither an accomplice nor a co-conspirator. And that's one of the few times in all of your study and practice that you're likely to see a duress defense, and furthermore, see that it succeeds. So this is a fact pattern that has allowed us to take a careful look at some fairly tricky laws of criminal law, particularly this duress defense, and some fairly standard criminal procedure issues that you're likely to see on the multi-state as well as the essays.